everyone. Today's session is going to be extremely important for all our viewers because we have very special guest with us. He needs no formal introduction. He is Professor Dr. Faizan Mustafa sir. He is the leading scholar of constitutional law and Vice Chancellor of NALSAR University of Law, Hyderabad. We welcome you, sir. We are honored and elated to have you here. Sir, as you have been important part of esteemed law fraternity and you are an eminent jurist, so how do you look at this journey? We would really like to know about it.
Well, Shivani, I think I continue to be a student of law in higher education. Every teacher who is coming to the class has to come fully prepared because there are students who challenge you in the class. And any class where you have just one-way traffic would not be considered as a good class. And I don't think I have made any significant contribution to the legal knowledge, so to say. But I have read some of the great works in law, and I have tried to present different views to my students, because the whole idea in a law school is that the students learn the art of making an argument. And while making an argument, not only you should know what would be the devil's argument, so to say, but also how to construct an argument. And I always tell my students, I won't be able to teach them law, but I would be able to teach them how to find law.
Since I have seen many of your interviews and it came to my knowledge that you are an avid book reader. So, sir, which is your personal favorite book and why?
No, it's very difficult to say. Recently, I did one interview on books that video is available. It's Himanshu who does this kind of programs on books. I would say number of books, but one of the first books which I read was 1984 by George Orwell, Gandhiji's Experiment with Truth, Nehru's Discovery of India. So there are many books. So every year you read some books, and some of those books have been really classics, and they had a huge impact on me. I would say that any good student of law should read during 5 years of his stay in a law school a minimum of 100 books. Every year they should read some 20 books or so. And they should read a lot of fiction and a lot of autobiographies, biographies, because there are things which you will not find in the textbook.
Absolutely.
And a good class by a teacher would be one where he brings all this knowledge together in the class, what he has read in autobiographies and biographies, that makes class more interesting.
So, since it has been a decade of you being a vice chancellor, so sir, how far the academics as a structure has changed, and when you compare it with your student life, how it has changed?
Now, when I did law, then you did not have any national law school. So law schools will come when I would be completing my LLM. And in the traditional model of legal education, Aligarh Muslim University's law department was a leading center. In fact, there were two great centers of legal education at that point of time. One was Delhi University, where you had Professor P.K. Tripathi and Professor Upinder Bakshi and Professor Nigam, Professor Lolita Sarkar. All great teachers were there in Delhi Law University, in Delhi, in the Campus Law Center of Delhi University. You can correct it, isn't it? It is the Campus Law Center of Delhi University. The other good center of legal education in terms of ranking also, I think it was number 2, was Aligarh Muslim University's law department, where you had Professor Virendra Singh Rekhi, you had people like Shiv Dayal, who was a great teacher. You had people like Professor S.K. Agrawal, and you had people like Zakaria Siddiqui, who taught me criminal law. People like Ahmad Siddiq, Misbahul Hassan. So you had great teachers. As I compare, my student days with today's academia, I can tell you there is a marked difference. During my days, teachers were really passionate about teaching. They used to invest a lot in the classroom teaching. And people used to look forward to classes of their professors. And after the classes in the mess and in the university departments, there used to be a heated debate about what the teacher has said. And that's why I say that I look at law as Professor Upinder Bakshi would call teaching by provocation, that we provoke students to think. So the whole class is all about provocation. Today, because of UGC, what has happened that many youngsters are more interested in publications. And therefore, their focus is about doing of PhD, about acquiring a certain API score. Then lot of events are held today in law schools. During our days, we did have a law society, but law society events were not, so many. In a year, you will have 4 or 5 events. But now every month in a law school, there is one event or another, which is good because, like as I said, if you look at my long career as the Vice Chancellor for good 13 years, I believe that this is a myth that the teaching takes place only in the classroom. We believe that a lot of learning takes place outside the classroom. And that is why during COVID, when the students were deprived of interaction with teachers and were deprived of peer learning, I felt really very, very sad about it, because they learn more from their peers than they learn from us. So that is another difference. And third, when I did law, then law was not a prestigious course, so to say. By that time, its prestige has gone down like anything. I recall that there was one India Today issue, which was about the dowry market. So if you are an engineer, you get 5 lakh. If you are a doctor, you get 10, 20 lakhs. If you are an IAS officer, you get 40, 50 lakhs. And the joke was, if you are a lawyer, you have to pay 2 lakhs. Now, national law universities have changed the landscape of legal education. Now, every year in the leading national law universities, you get students who also qualify for IIT, who also get into NEET, and they leave MBBS and BTech courses to join law. The average age of the class has gone down. But there is a flip side of this. Shivani, the flip side is, in my class, I had a doctor. I had several engineers. I had people who had done history, people who have done zoology, people who had done MSc biotechnology. So in terms of multidisciplinarity, since you are doing law in a traditional university which had 70, 80 departments, you had experts in every field. While in a national law university for social sciences and other subjects, you don't have many senior people. Some senior people are there, but they are an exception. And the focus is entirely on law, even though we at NALSAR believes in integration of knowledge, and we emphasize humanities a lot. In fact, I have been saying it for some time, and I did tell it to Professor Madhav Menon, that National Law University's Vice Chancellorship should now be open also for experts of humanities. It will do a lot of good to the national law universities if not only people who are professors of law, but also professors of literature and humanities and social sciences, with whom we have a natural wedding, they should also be eligible. In fact, you would be surprised, Shivani, I have been writing on a subject of selection of vice chancellors, and I have been saying that this UGC rule, which says only a professor would be eligible to become a vice chancellor, is not the correct rule. We should also open vice chancellorship for the bureaucrats, for the army officers, for the judges, because some of the judges were excellent vice chancellors. Chief Justice of India, P.B. Gajind Gatkar, after his superannuation, became the vice chancellor of Bombay University. You had General Zamiruddin Shah as the vice chancellor in Aligarh. You had Mr. Hamid Ansari, a career diplomat, a foreign service officer as vice chancellor. You had K.R. Narayanan as vice chancellor. So some of the bureaucrats had made excellent vice chancellors. Ideally, we should cast the net wider. Because vice chancellorship is not about just academic leadership. It is not necessary that the vice chancellor himself should be the best of the academic, but he should create that ambience so that academics on the campus flourishes. That is his job. Therefore, you need good leaders. You need academic leaders. And in the huge traditional universities, at times, you have problems of indiscipline. So you may need IAS officers, or you may need army officers also as vice chancellors. So we should not narrow down our search for a vice chancellor. That has been, my argument.
So what is the basic difference between national law universities and other law universities? So because after CLAT, the people have started believing that law has many career opportunities, which was never the case before. And आजकल काफी students CLAT में appear करने लगे. So sir, what is your view about this?
National Law Universities CLAT की members हैं, except National Law University Delhi. But you have 3 law universities. You have a law university in Karnataka. You have a law university in Chennai. And you have now Dr. Ambedkar Law University in Rajasthan, in Jaipur. Now, these are the law universities which have affiliated colleges. So, Mr. Dev Swarup is the Vice Chancellor of Dr. Ambedkar Law University in Jaipur, and 82 affiliated colleges are under that university. So, in terms of influence and the extent of work which law university will have is much more than a national law university will have, which has a small number of students on campus. But national law universities, being fully residential universities, selecting best of the candidates to be LLB program, have, as I said before, enhanced the prestige of legal education. Even though their original purpose was to enrich the bench and bar, but many of our students, at least in the older NLUs, they prefer to go corporates, and they give very, very attractive, packages. But law opens a lot of opportunities. If you want to write civil services exam, then the law is a good option. If you want to be a judge, then nobody other than you is eligible to write the judicial services exam. I always say judicial services exam is the easiest competition in India. If you are writing civil services, people from all disciplines will appear. So you will have PhD holders, you will have MSc, MA, BTech IIT, you will have MBAs, IIM students. So the competition is too much. As you know, in the civil services prelims, about 5 lakh people will write the exam. And at the end of the interview, in terms of IAS proper, you may hardly end up in the general category with about 35, 45 officers. But in judicial services, only a law graduate can write the exam. And lately, the judicial services conditions have also improved. So that is another option. Then every corporate needs legal advisor. Banks need legal advisors. Insurance companies need legal advisors. So, lawyers make money when business is flourishing and also when companies are winding up. So when you had this Lehman Brothers collapse in United States, even IITs were not able to place their students, but national law universities were easily able to place their students because for the winding up of the companies, you really need lawyers. And of course, public prosecutors, only lawyers can be public prosecutors. Most of the law graduates are also in the politics. So if you look at Lok Sabha and Rajya Sabha in terms of professions, legal profession would be, having most people. Most of the law graduates will be the MPs at any given point of time. And our entire freedom struggle was led by the lawyers. Why? Because, I entirely disagree with Shakespeare, who said that the first thing we should do is to kill all lawyers. I always say that Shakespeare was wrong because we should not kill lawyers because we don't have their replacements. Lawyers fight for rights and lawyers fight for other people's causes. So Indian freedom struggle, Shivani, is very interesting because the kind of leaders it has thrown up, no other freedom struggle in the world had thrown up that kind of leadership.
So as you have quoted many times, the student maketh the institution. What is the importance of this quote?
This is a whole philosophy of how should we govern a higher education institution. I have been in Aligarh, I have seen all kinds of vice chancellors. Since I'm in higher education, I have been studying about other universities. The vice chancellors who treat university as a district generally fail as vice chancellors because university administration is entirely different from the administration of a district. Two, vice chancellors who treat themselves to be, above all and center of all power, like an emperor. They behave like an emperor. They are not accessible to students and the faculty members. They also fail. University administration has many stakeholders. So you have teachers, you have non-teaching staff, you have students. In my opinion, the primary and the main stakeholders in any university are the students. Very interestingly, in the administration of the universities, we do not give them due importance. And that is why we as administrators face student protests. Because we never talk to them. We don't understand their problems. In fact, in national law universities, compared to traditional universities, there is more conversation between the administration and the students because the size of the university is very, very small. But in traditional universities, one-to-one conversation between students and vice chancellors is extremely rare. I feel that a university is all about students. And therefore, students, what they want to study. That is the whole reason of choice-based elective system. I am absolutely against the mandatory system. In fact, I am also against that too many subjects should be made compulsory by the regulator. The regulators should trust the universities. Once they are conducting the bar exam, then universities should be given the freedom to design their course. Now, in the current scheme, there is not much scope for the universities to experiment. Knowledge creation requires a lot of freedom. Regulators must give that freedom. As far as administration is concerned, I believe every vice chancellor must have lot of conversation with their students. I hold lot of open houses. Even during COVID, we had, online open house. We also conducted the online union election. Why? And vice chancellor should also teach, because if they go to the class and they teach well, and before the class, after the class, the students will tell them their problems, they would be sorted out. Between administration and students, there is adversarial relationship. But between teacher and taught, there is a relationship of affection and a relationship of respect. And therefore, I personally feel that to be a good vice chancellor, one must do a lot of teaching. In all 13 years, Shivani, I have met students without appointment. Whenever any student wants to meet me, I'm available. If there is some meeting going on in my office, I go outside my office, meet them, sort out their problem. And when therefore I came to NALSAR, what I did, I involved students in the administration of university in the big way, in the selection of books for the library, in the evaluation of tenders. All tenders which we do, I would nominate to the tender committee the SBC president. I also involved them in the making of regulations. When we are making the hostel regulations, when we are making the sexual harassment regulations, when we are making academic regulations, when we are making scholarship regulations, gold medal regulations, in all these regulations which are concerned about students, I think let them be a party to the making of law. And my experience has been that though at times they will have a wish list which will be very, very long, but when you talk and you say we cannot give you this, we cannot give you this, you would reach a point where you think there will be a consensus. They would also say that we would be governed by these regulations. You also think that you had a fairly good deal with the students. And once there is an ownership of students of university regulations, I think that makes the administration extremely easy, because they themselves frame their regulations. And I trust my students. Many people may say, some of them may also indulge in discipline. Yes, they do. But look at their age. You are asking me the difference between the traditional, law departments and NLUs. You are getting extremely young people. They are just 18. Some of them, turn 18 when they join first year. So as a result, I think that this whole idea of what do you mean by discipline in a university? We are a university. We are not a prison. I am not a jailer. I am a teacher. I don't consider myself even to be a vice chancellor. And therefore, at times when students may indulge even in indiscipline, I personally feel that punishing them may not necessarily give you best of the results. I have taught criminal law for many, many years. I know the limitations of criminal sanctions. I have done hand-holding of many students and saved their career. At times they do commit mistakes. At times they may abuse your liberty model also. But when you weigh pros and cons of this model, where students are part of the administration, I feel it is a win-win situation both for the teachers as well as for the students and for the vice chancellor, because after all, they are all adult. We are not administering somebody who is our subject. Isn't so? They are our co-learners. We also learn through their questions. We also learn through their comments. So has to be a joint venture. Administration of the university, in my opinion, has to be a joint venture of teachers, student, and non-teaching staff.
As previously, काफी सारे जो students होते थे जब वो 11th 12th में होते थे, so they had few priorities. उसमें से generally काफी सारे बच्चे या तो medical field के लिए जा रहे होते थे या IITs के लिए. But after CLAT, this perspective has changed. Now they have started seeing great opportunities in law. Sir, according to you, what is the future of law?
The law is a discipline now, I think, has come of age. I give you that example. When our freedom fighters were lawyers, because in the 19th century and first half of the 20th century, law was the most prestigious course. Somehow in the decade of 60s and 70s and 80s, so many law colleges, evening classes started. There were teachers of mine who had done LLB and MA simultaneously, because two courses one could do at a time. Again, UGC is now saying that you can do two courses. So the seriousness which is required for legal education was somewhere lost. With the establishment of National Law School of India University at Bangalore and then subsequent NALSAR and several other national law universities, this has changed. Now, since we don't do law after MA, after BA or BSc, we do it after 12, just like MBBS and BTech. We also catch them young. That is the whole idea, catch them young, get people who are really interested in doing law, impose the requirement of attendance. So as a result, law as a course has now acquired huge prestige, isn't so? And the kind of job opportunities which I already told you in response to one of your earlier questions make law a very, very interesting discipline. In fact, Shivani, you would be surprised that in our country, after 12th, NEET is considered to be most difficult because you have very few MBBS seats. But after doing MBBS, they get the maximum frustration. Why? Because MBBS is not good enough for anything. And you have extremely small number of MD seats available. Therefore, people who complete MBBS, they get depressed because they are not able to get a MD or MS seat. In fact, many now want to do even DM. In comparison to MBBS, most good BTech students get some job. All IITians definitely get jobs or get foreign placements or admissions in foreign universities. All national law university students get good placements and jobs. So while celebration is maximum when you make it to NEET and you join medical, but once you complete your medical, you would be the most frustrated student. And that's why, BTech and law are much better and secure options. And any society which is interested in rights, our constitution, was intending to bring in a rights revolution. If you are interested in rights, you must do law. Get your own rights and help others to get their rights. You should, the whole focus of legal education we have changed. Earlier, we were making people good advocates. They must have skills in advocacy. So they will be the most competent and skilled professionals in their own right. Today, my job at NALSAR or of my colleagues in other national law universities is to produce socially relevant lawyers. We want to produce justice soldiers. We want to produce people who understand the pain of fellow human beings. So they get a sense of injustice in the society. So we have changed the whole focus of education. It is no more legal education. It is now justice education. And as we say, to understand this complicated concept of justice, it is better to start understanding what is an injustice.
So now in the current model, many students, many law aspirants, they are now more inclined towards judicial services. Before they had option of going into private firms and other private fields, but now they have started seeing judiciary as a really good option. So sir, what is your thought about this?
No, because the top corporate jobs are few. With more national law universities, the number of law graduates from NLUs is increasing. With economy not doing that well, we are having the worst unemployment scenario of last 45 years. So since not many corporate jobs are available, they have to write judicial services and civil services exams. And as a result, every year when I go to teach, civil servants in the Lal Bahadur Shastri Academy in Mussoorie, I see so many national law universities graduates are there who have made it to civil services. And of course, anyone who has done law can definitely write the judicial services examination. I just told you that they are the only one who are eligible.
Also, I have seen your many interviews on current legal developments. From a very long time, it is proposed that Indian judicial services should be there. It should be implemented, but unanimously इस पर कोई decision नहीं लिया जा रहा है. So, sir, should it be done?
इस पे शिवानी इसलिए नहीं लिया गया क्योंकि जो हमारा फेडरलिज्म है वो रियल में जुडिशियल हायरार्की में द चीफ जस्टिस ऑफ द हाई कोर्ट is not subordinate of Chief Justice of India or judges of Supreme Court. In fact, this whole collegium system has a problem because now the collegium judges, in a way, have a higher status compared to non-collegium judges. So, Chief Justice of a High Court not under Supreme Court or Chief Justice of India is a perfect example of federalism. Now, many states are not on board. Unless you have a consensus on this issue, it would be difficult to have judicial services. There was some proposal 2 years ago. I had also drafted a bill for that when Chief Justice Bobde was there. But due to COVID, that bill could not be passed. But I'm sure that the current government is committed to get Indian judicial services, and it would become a reality very soon.
My last question to you. What is your advice for all the CLAT aspirants?
Yes, I have been saying it, for some time. I am basically opposed to any coaching. I feel that the CLAT exam, should be so designed that people who are best suited for law are selected. And nobody is able to game our exam. What is now happening that people from metropolitan cities, people who have resources are able to, get coaching from the best of the institutions. And the diversity in national law universities is adversely affected. People from rural areas, from small towns and villages are not able to make it except in the reserve categories. Two, I feel that we should not test any prior knowledge. We should not test their memory. Ideally, I have been saying it in the CLAT meetings for years, that the legal section should not be there. Because they are coming to learn law from us. It is unethical on my part to test them in law. And if you look at the questions in the legal sections, some of us find it difficult to answer them. You had 200 questions in CLAT. When I became the president of the consortium, I said these are too many. I wanted to reduce it to 120, but then we got the consensus at 150, so I reduced 50 questions. We also said that let us give them paragraphs because we want to test their ability to read fast and to read the complex text. That's how paragraph and questions, the comprehension based questions were introduced. I'm also against static GK. Therefore, we said we will have current affairs, but these current affairs should also have some kind of not testing of rote memory, but what is happening around. So any aware +2 students who has not put in any extra effort should be able to qualify our exam. But it's a whole body. There are a number of experts who set the question paper. Then there would be a moderation committee which selects some questions. And every year there is some controversy about it. Then another expert committee is constituted which examines those objections. So there have been some very positive reforms which have been done in CLAT in last 2-3 years. And some more reforms I am sure would be done in near future.
Your answers were really inspiring, and it has inspired all our viewers and me as well. Thank you for giving me this opportunity today, and I'm really grateful. Thank you for gracing us with your presence.
Thank you,
Thank
Shivani.
you.